Okay, did you know that real estate has Miranda rights? Well, not exactly. However, there is a state law that mandates that real estate agents present this form upon first substantive communication with a buyer or a seller. What it does, it describes the difference between being a customer and a client, and it describes the different agency relationships that you could potentially enter into. As a customer, we are not held to fiduciary duties. However, we need to disclose all material defects pertaining to the physical condition of the property. We need to treat both the buyer and the seller honestly and not knowingly give false information. We need to account for all money and property received from or on behalf of the buyer or the seller, and we need to comply with all state and federal laws related to real estate brokerage activity. So as a customer, we need to treat you fairly. We can provide you information, but we can't analyze that information. We can't render an opinion on that information. As a client, we're held to fiduciary duties of loyalty, obedience, disclosure, accounting, confidentiality, due diligence, and reasonable care. We can provide a much better service as a client versus a customer. So as a client, we put your needs ahead of our own. One of the big things, again, is confidentiality. What you tell a real estate agent is not confidential until you actually have a written agreement to be represented by that agent. Now, there are different types of agency relationships that are available to you in the state of Maine. One is single agency. Single agency is when a company and all the affiliated licensees within that company represent a buyer and a seller, okay, or represent a client. The more common brokerage relationships that are found in Maine are disclosed dual agency and appointed agency. Disclosed dual agency is when one agent represents a buyer and a seller in the same transaction. Now, there are some agents and agencies that believe there's a conflict of interest there, that it's difficult to represent competing parties in a transaction. So it is something that can legally be done, but buyers and sellers need to be made aware that there's a limited amount of duties that an agent can provide in a dual agency situation. So they cannot disclose the motivation of the seller to sell, the motivation of the buyer to buy. They can't disclose the negotiating strategy of either party. They can't disclose the seller's willingness to accept less than what the asking price is. And they can't disclose the buyer's willingness to pay more than the asking price. So there's certain things that they're not able to share with their dual clients. However, again, some people look at it as if it's an attorney representing competing parties. So another agency relationship is appointed agency. Appointed agency is when one agent is representing a buyer and a separate agent is representing a seller. You get to decide what type of relationship you want to have with your agent. So remember, without a written agreement, we are not supposed to advise you. New rules and regulations regarding realtors requires that we have a written agreement before showing you a property other than our own personal listings. So in any case, if this form is presented to you, don't be alarmed. It is not a contract, as it says specifically. You can sign 20, 30, 100 of these, and it doesn't bind you to an agent. The only time you should become concerned is if you meet with an agent about potentially buying a property or selling your home, and this form isn't presented. The state does not mandate that you sign it. The state only mandates that we as agents present it to you. I can tell you that customarily, I ask my customers to acknowledge this form. That way, my designated broker knows I actually went over the form and didn't just hand it to them. Thank you for your time. Make it a great day. Okay, so hopefully you watched my first video that described the Maine Brokerage Relationship, which discussed the different relationship options that you have available to you when you work with a realtor specifically. So this form is the exclusive buyer representation agreement. There's a number of different agreements that you can enter into. This one says you're going to work exclusively with this one particular agent to assist you in buying a home. So first of all, at the top, you can see that it says agency, not agent. So when you sign an exclusive buyer representation agreement, you're actually signing an agreement with the agency, not the agent. All right. So that's an important distinction when you decide what type of relationship you want to have with your agent. So we talked about appointed agency, right? Where one agent is appointed to represent the buyer in a transaction, one agent is appointed to represent the seller. This exclusive buyer representation agreement is called the combo form. It's the form that's most commonly used by real estate agents, but as I mentioned before, there are other alternatives that you will want to discuss with your agent. However, this is the form that I typically use, so this is the one that I'm going to do this video explanation on. I'm going to give you a Cliff Notes version of this form. When you meet with me or when you meet with your agent, you should expect a little more detailed explanation of everything that's within this form. So you have an agreement with the agency, and then they say, well, this is the agent from the agency who will be appointed to represent you. So this is the name of the agent, and then they put in the type of license that they have. There are 3 types of licenses in Maine. There's a sales agent. A sales agent is a realtor who's been in the business for 2 years or less. There's an associate broker. An associate broker is an agent who has been in the business for at least 2 years. And then there's a broker. So a broker, the distinction between an associate broker and a broker is that the broker has taken a additional training and education to get that license designation. All right. So the first part of this combination form is appointed agency. As I mentioned before, one agent's appointed to represent the buyer, one agent's appointed to represent a seller in that relationship. So it goes on to say that if your agent who's appointed to represent you is unavailable for any reason, another agent can be appointed to you temporarily to represent your interest. Or if you're simply not happy with your agent, another agent within the company can be appointed to you on a permanent basis. So this is saying that yes, no, that you agree, you get to decide if you agree to appointed agency. Then the next section talks about dual agency. Again, we talked about dual agency and the fact that it's one agent representing a buyer and a seller in the same transaction. The majority of people I speak with have an issue with that. They see it as a huge conflict of interest. It is legal to do, however. You have to decide, though. Do you want to agree to dual agency? Yes or no? Or you can decide not to. All right. So that's a conversation that you want to have with your agent and to see what's in your best interest. And as I mentioned before in the previous video, here are the things that an agent cannot do, cannot disclose in a dual agency situation: the willingness or ability of the seller to accept less than the asking price, the willingness or ability of a buyer to pay more than offered, confidential negotiating strategy not disclosed in the sales offer, and the motivation of the seller for selling or the motivation for a buyer for buying. Beyond that, there's nothing off limits in terms of confidentiality. So you decide. Do you want to agree to appointed agency? Do you want to agree to disclose dual agency? Do you want to agree to either or? Those are decisions that you'll have to make in counsel with your agent. So this is where we put in the name, your name as the buyer. And again, the fact that you're retaining a particular company to assist you. There's a time frame. That's an important aspect of this. It says that the agreement's going to begin on a certain date and expire on a certain date. So with regards to that date, that's all negotiable. Okay, all these forms have negotiable aspects to them, and the time frame is something that you consider. You can make it a one-day listing or one-day agreement with your buyer agent if you and the agent agree to. The next thing to talk about is the areas. All right, so here's something that you really need to consider. A lot of agents will put Maine in here, the entire state of Maine. Now, here's where I have a problem with that. Even though legally I can represent you in buying a home on any part of the state of Maine, I don't think it makes sense for me to do so. And here's why. there are certain parts of Maine where I am less familiar with. So I don't feel like I can provide full advocacy in a town that I'm not familiar with when I don't know the difference between one neighborhood and another in terms of value. So my suggestion is that when you're going over this form with an agent and considering their representation, ask them, where's the location that you typically work in? So when I'm doing these buyer agreements, I'm usually staying within a 35, 40-minute mile radius of the Waterville area because I was born and raised in Waterville. That's the area I know best. So that's something, a discussion that you want to have with your agent, is the specific area that it's encompasses. You can even, again, negotiate it between you and the agent. You can decide to have it specific to the properties that they show you on that particular day. So all negotiable, have those conversations, what you're willing to accept and what the agent is willing to accept in these terms. So the agent's responsibilities to, under this form, are to make available to you their professional skills in locating and negotiating property, assist you to determine current market value. Okay. That's one of the biggest things we can do as agents, as your advocates, is that when you find a home, we're going to do an analysis for you. We're going to let you know what we think that property should sell for. This form does say, if requested by the buyer, I will tell you this, I make it a habit of doing a market analysis, whether my buyer requests it or not, because I want to advocate for my client. I want to make sure that if they are paying more than what I determine to be fair market value, they can make that decision. But I feel it's my responsibility to inform them on what fair market value for that property is. The next thing that this does, it holds the agent to confidentiality. Again, that's huge, right? The only person who may know that you're looking to buy or sell would be the designated broker owner of that agent, if the agent needs to speak with them for advice. In this agreement, the agent can assist the buyer, if requested, to locate properly professional assistants such as surveyors, inspectors, lenders, things of that nature. The buyer's responsibility, okay, so here are the things that you're committing to, would be to work exclusively with the agency, refer all properties of interest, and conduct all negotiations through the agency for any property of interest for the buyer. You would furnish the agency with any personal and financial information to verify your ability to purchase a property. That doesn't mean the agent needs to know how much money you make. They don't need to know how much money you have in the bank. However, if you can provide your agent with a pre-qualification letter or a proof of funds letter that you can send along with an offer, that's going to put your offer in a much better position. And the bottom line is, your agent will want to know what type of financing you're using to be able to best advise you on finding the house that best fits your type of program. And sellers will want to know that the buyer has been to the bank as well and that they're qualified before spending time to prepare for a showing. So furnishing your personal financial information is all about actually protecting your interests in this transaction. So also it says you can consult the agency before visiting any open house or contacting any other agency or for sale by owner property to avoid any confusion over agency relationships. So if you're going to be going to an open house, as your agent, I would just let you know what to mention to the agent who's hosting the open house when you arrive. With for sale by owners, this agreement does not exclude for sale by owners. So if you find a for sale by owner, I would highly recommend that you give the phone number to your agent rather than calling them directly to avoid any confusion over representation and potential costs. This says that you're going to make an independent investigation and determination that the neighborhood amenities meet your needs. Our scope is the home and the land that it sits on. However, if we know of something about an area, we know that a bunch of buildings are about to be torn down and they're about to put a strip mall in there, that's something that we need to share with you as your agents. However, it's saying you need to do some due diligence yourself as well. Also, E, it says request in writing that agency investigate or verify specific issues and receive agency's agreement to do so. F says retain sole exclusive responsibility to evaluate the qualifications and make the final selection of any proper related professionals. So I've been in the business for 24 years, so I've worked with a lot of building inspectors. What I typically do for my clients is I give them 3 or 4 names, and then you can call to find out which inspector you will choose based on whatever criteria you're using. Compensation. This is one of the biggest questions, right? People want to know, how much am I going to pay? There is an option for an agent to collect a retainer fee. A retainer fee is the amount of money that an agent might collect from you in the event that you don't purchase. So let's say we have a 6-month agreement, and in that 6 months, you don't buy anything. The bottom line, the nature of the business is that as an agent, I won't get paid for those months of showing you properties and miles on the car and whatnot. So what some agents do is they accept a retainer fee, and that fee is lost to the agent in the event that you don't purchase something within the time frames of your agreement. Again, this is all negotiable. Have that conversation with your potential agent. So for listed property, this is where you have a negotiated amount that your agent is going to get paid in the transaction. It can be a specific dollar amount, or it can be a percentage of the purchase price. And it does go on to say that the payment can come in multiple ways. It can come directly from you, the buyer. So you may tell your agent, this is what I'm willing to pay you. At the end of the day, it's going to come out of our bank account at the end of the day, and we'll pay you directly. The other option is to try to negotiate this buyer agency fee to be paid by the seller. In many cases, the seller has already agreed to pay the buyer agency a certain fee. The only thing to be wary of is that whatever you have in this number, your agent, if the other agency or the seller, what they're offering for compensation doesn't match the total amount that you have agreed to pay your agent, that agent can ask you to make up the difference. There are a number of ways to make that happen. I'm not going to get into those details right now, but in any case, you'll want to have that conversation with your agent to know what his or her expectations are. For unlisted property, so with a for sale by owner, you may have a different fee that's negotiated. In a for sale by owner situation, I can tell you that as an agent, we're going to do a little more work. We have to make sure that the seller is doing everything they need to do to make sure the closing happens on time. We need to meet with the seller to fill out the property disclosure form and make sure the accuracy of that to the best of our abilities. We need to make sure the seller is following through on utility transfers at the end of the transaction. So because there's some additional duties involved when a for sale by owner is when a buyer is purchasing a for sale by owner, this cost here might be a little bit different. There's a carryover clause that says that if you buy a property within 6 months of the expiration of our agreement, we as agents will be entitled to a brokerage fee unless you sign one of these with another agency. Any property that we present to you within the time frame of our agreement, whatever that agreed upon time frame is, within 6 months after the expiration, if you were to buy it, we're still entitled to a brokerage fee unless you sign one of these with another agency. So this also says that the commission will be earned when a contract has been accepted by a seller and all contingencies have been satisfied. So we get paid at the closing table. Disclosure agency for compensation policies. Yes or no? The agency's policy is to compensate other agencies. So you will want to have a conversation with your agent to know whether they actually compensate other agencies or if their agency asks their sellers to pay directly to a buyer agency. If yes, this agency's policy is to compensate all real estate brokerage agencies in the same manner. So again, an important note to discuss that if your agency does pay other agencies, you want to find out if that is a consistent payment or if there's a potential where one agency could receive a little bit more or less. You might get paid, or their agent, may get paid a little bit more or less, depending on the agreement with that company. One thing I should also point out is whatever's on this compensation form, your agent cannot get paid more than that. Under any circumstances, It's not a situation where your agent can get paid more. All right, so let's see. Okay, other conditions. Other conditions. This agreement includes property for sale by owner, property not currently for sale, so things that are going to come on the market anytime soon, unlisted new construction, and property listed for sale by this any other agency. All properties are acceptable at the sole and absolute discretion of the buyer. Buyer agrees that agency and its agents may represent other buyers in the acquisition of the same property. So here's what that's saying. I might be showing you a property in Oakland. There may be another agent within my office who's also showing that to a different buyer. Or I might have a different buyer that I'm showing that property to. In the event that that's the case, I can't let you know about them, and I can't let them know about you if you are both clients. If one is a customer, my fiduciary duties go to my client. So in that situation, I could tell my client that I showed the customer the property, if that makes sense. We will cooperate and compensate other agencies, if appropriate, in locating property for buyers under this agreement. Agency will not be responsible for independently investigating or verifying specific information not related to the property itself. Agency will not be responsible for independently verifying information supplied by other licensees, outside professionals, or government agencies, third-party advice, data, or specific information, unless agreed to in writing by both parties. Agency will not be responsible for determining the applicability of or compliance with any federal, state, or municipal codes. We're not codes experts. Buyer acknowledges agency's advice to seek legal, tax, and other professional advice. I've been in the business for 24 years. I'm pretty resourceful in terms of getting answers, but I like to tell people I'm not an attorney. I'm not an accountant. So if you have questions I can't answer, I'm going to refer you to professionals in those fields. Buyer authorizes the disclosure of information herein to Maine Listings. So there may be a time where someone at Maine Listings may ask for a copy of this to verify that we actually do have a written agreement. Because as I mentioned before, by law, we're not supposed to show you property unless it's our own listings without this agreement. So if Maine Listings were to contact us and ask for a copy, this authorizes us to send it to them. For properties not listed in the multiple listing service, this says that you will allow your agent to publicize the sale of this property in the multiple listing service for marketing, statistical, and appraisal purposes. Here's where you can put in some other conditions. This says that you did or did not receive the transaction booklet. It is common practice that for any buyer who's purchasing a residential property, this booklet is provided. Most companies, I suspect, have a company policy that requires that. What it is filled with commonly asked questions by people who haven't bought or sold in a while or never in Maine, with answers to those questions, which might prove very useful to you. This mentions that buyers, you may be monitored by audio or video surveillance when you go through a home. So I will remind you, or your agent hopefully will remind you, when you're seeing a property, not to say too much about the home when you're going through. You don't want to go in and say, I'd pay double the asking price for this, because someone could be listening to that. Nor do you want to make any comments about the personal decorations that a seller might have. Someone may hear that, may become offended, and then may not be willing to work with you on an offer. Let's see, agency and buyer agree that this shall create an agency relationship. Parties shall be represented without regard to race, color, familial status, religion, sex, physical, mental disabilities, ancestry, sexual orientation, gender identity, national origin. So those protected classes, we're going to show property irregardless of any of those protected classes. This says that you consent to receive a fax or other electronic transmissions. And this agreement may be signed on identical counterparts with the same binding effect as if for the original signature. So electronic signatures are still binding. This says that pursuant to Maine Electronic Uniform Electronic Transaction Act. The parties authorize and agree to use electronic signatures as a method of signing this agreement. It doesn't mean that you have to. If you don't have access to email, then electronic signatures will be a challenge. But for the majority of the people, this works very appropriately. Just understand what's really important is that your agent review this with you and not just send it to you for signature. That's the danger of electronic signatures, is that oftentimes these forms aren't gone over in thorough detail. Then you'll be asked to provide additional contact information. The last portion of this section is a cyber fraud, wire fraud advisory. So cyber fraud and wire fraud is on the rise. Millions of dollars have been lost in the state of Maine from people who are basically just stealing your money, all right? And it's happening in real estate. So there's going to be times when someone's going to ask you for your social security number. We'll talk about different measures to protect that. Be cautious that if you receive any kind of communication from your email, any kind of communication from your agent that doesn't seem quite right, to check with your agent to make sure that they were the ones that actually reached out to you. If you look at this really quickly, these two emails look the same, but one's Acme and one's Arcney. That's something that these scammers might do to try to pretend to be your agent. So be wary of that. This goes on to say the things that you can do in the event that you become a victim of fraud, as well as some 4-point bullet items, just to be careful to make sure that you're protecting your personal information. In the event that damages do occur, there's even a number at the bottom for you to contact. So this is the Maine Buyer's Agency Agreement. This is the one that my company uses. So this is the one I presented. But again, there are other options available to you, even within my company. So happy to discuss those with you at any time. Make it a great day. Okay, this video is going to be a detailed explanation of the exclusive right to sell listing agreement that's commonly used by realtors in the state of Maine. Now, just like the exclusive buyer representation agreement, there are multiple forms that you can discuss with your agent and decide which one is right for you. I'm going to talk about the combo form that talks about appointed agency and disclose dual agency. We talked about that in the video for the Maine Brokerage Relationship Form, as well as the buyer agreement form. But that disclosure is also made on the exclusive right to sell listing agreement. So just like with the buyer's agreement, notice at the top of the form here, your agreement to sell your home is with the agency and not specifically the agent. So you will then have an option within the agency to choose what type of relationship you want to have with that agent. You can have an appointed agency agreement where that one agent is appointed to represent you in the transaction, and another agent would be appointed to represent the buyer, whether it's within the same company or another company. So appointed agency, again, one agent represents a buyer and one agent represents a seller in a transaction. So the company will appoint an agent to represent you, and they will say what type of license they have. There are 3 types of agent licenses in the state of Maine. There's a sales agent who's been in the business for less than 2 years. There's an associate broker who's been in the business at least 2 years or more. And then there's a broker who has been in the business at least 2 years and has taken an additional class training to be able to get their broker license. So with appointed agency, in the event that your agent is unable to assist you further, or for whatever reason is unavailable, another agent can be appointed to represent you temporarily in their absence. Or if you're not happy with your agent, another agent can be permanently appointed to represent you. So you can decide whether yes or no that you agree to enter into a relationship with your agent as an appointed agent. The other option that you have is dual agency. We talked about dual agency again earlier on, how many buyers and sellers feel that it's a conflict of interest having one agent represent a buyer and a seller in the same transaction. There are certain things that an agent cannot disclose in a dual agency situation. They can't disclose the willingness or the ability of the seller to accept less than the asking price. They can't disclose the willingness or ability of the buyer to pay more than they've offered. They can't disclose the confidential negotiating strategy of either party, and they can't disclose the motivation of either party. So you will have to have that discussion with your agent to decide whether you want to have an appointed agent representing you or a dual agent representing you, or you can actually agree to both of these. So this says that you have read and understand the agreement and that you hereby choose to consent or not consent to dual agency. Compensation is one of the biggest discussion topics, right? When you're going to sell your home. So first of all, agency commissions are not set by law and are fully negotiable. You need to understand that, right? So in consideration of agency's agreement to list and promote the sale of the property, all or part of the property, in some circumstances, you might be retaining 5 of your 10 acres that come with your home, right? So we need to know whether you're selling all or part of the deed that you have. It talks about the municipality that it's in, the county that it's in, and the specific address that it's in as well. So along with that, it's the book and page number. Sometimes there's multiple book and page numbers for your deed. And then you go on to the asking price. Now, the asking price, we're not going to go into full details of how we arrive at that because that's a whole nother video that's probably 4 hours long. But in any case, this is where we put in your asking price that you agree to sell your home for. And it does say, or any price that's agreeable to you. And this is where you have the negotiated commission amount, right? So in years past, many people would have one commission that then would be split in various ways between the buyer agency and the listing agency. So this is a much more transparent form than what we had before. So what it does is it shows what your negotiated commission is for the listing agency. And then they talk about, okay, what if a customer comes in? If a customer comes in, is your agent going to charge a little bit more because they'll be having additional duties, even though they can't advise that customer, they can't represent that customer? They still have additional duties to make sure that customer is doing everything they need to do to make sure that you close on time. So a customer does not have a written agreement to be advised by that agent who's writing the offer. And then there's buyer agency. When the buyer's coming in and actually has representation, legal representation, written agreement. So you need to ask your listing agency if their policy is to cooperate with other agencies acting as buyer agents. Ask them if the agency's policy is to share compensation with the buyer agencies. If yes, then the seller, you consent to this policy, and you can offer a range, if you so choose, of that commission to be paid to the buyer agency. So can't get into details of what other agencies do because every agency does things a little bit differently. I can tell you that at my agency, we do not compensate other agencies directly. All right. So our policy is no, we do not compensate other agencies. Transaction brokers is when an agent is assisting a buyer in purchasing a property, but they don't have a written agreement to advise that buyer. You need to know whether your agency's policy is to cooperate with those type of agents. And if it's their policy to share compensation with those type of agents. And then if yes, seller consents to this agency's policy of offering cooperative compensation within a certain range. As you can see, there's a lot of negotiating that needs to happen here. So you negotiate the amount that you're going to pay your listing agent. Okay, so you will have an option to decide whether you're going to offer any kind of buyer agency fee to a buyer agent, right? So you need to have a discussion with your agent to talk about the pros and cons of doing that. So you need to understand the merits of doing it and the merits for not doing it. If you do, then you can either choose not to specify an amount at this time and decide how much you're going to give that buyer agency, basically based on how good the offer is in your eyes, or you can agree to offer a direct payment to the buyer agency in a specific amount or a specific percentage of the purchase price. You can also offer buyer concessions. So you can choose to do both. You can choose to do one or the other. So a distinction between the two is a buyer concession is you are offering a concession to a buyer that they can use towards buyer's prepays and closing costs and or payment to their buyer agent. If yes, you can choose not to determine a specific amount at this time, or you can choose a specific dollar amount or percentage. All right, so yes or no? This agency's policy is to compensate other agencies. Just like we saw in the buyer's agreement, your agency that you're working with will either have a policy to or a policy not to compensate other agencies. If yes, this agency's policy is to compensate all agency brokerages in the same manner. So do they pay all agencies the same, or they pay certain percentages different to different agencies? And this agency's policy on paying commissions to affiliate licensee is greater for in-house sales versus sales involving a cooperating real estate brokerage. So does this agency give more commission to the agents involved when it's an in-house sale? That's something that you want to consider, and whether there's any potential issues with that. Term of the agreement. Everything in here is negotiable, right? So you decide when or how long you want this agreement to be for. Have that discussion with your agent, have a mutual agreement on the time frame for the agreement. And it does have the carryover clause, which is also found in the buyer agency agreement, which states that if we provide information on the property to a buyer in the time that we're working together, negotiations shall include providing information, showing the property, presenting offers on the property. If we follow those any of those items in the time that we're working together, and then the agreement expires, and then the buyer approaches you directly to buy the property, we're still entitled to a brokerage fee for up to 6 months, unless you sign one of these with another agency. So here's your duties. Upon signing of this agreement, in the final closing, you have to disclose all the information about the property, adverse or otherwise, right? So, and hold us harmless for any failure to disclose that information to a buyer. Referral increase to the agency. So if you're out there, you're raking your yard, getting it ready for winter, and a buyer stops to ask you questions, you want to make sure you have them contact us so that we can get them pre-qualified to make sure they're able to purchase your home before allowing them in or answering too many questions. This says that you convey the property by a certain type of deed. Could be a warranty deed, could be a quitclaim deed, could be an estate deed. This says that you, yes or no, authorize a for sale sign. You'd want to talk to your talk to your listing agent about the pros and cons of putting a sign up. Authorize the advertising of the property. For some reason, some people may choose not to advertise the property. They want to solicit the assistance of an agent who's knowledgeable in the industry to help them sell, but just don't want to advertise the sale. Believe it or not, that does happen from time to time. To authorize to have a key or a lockbox on the property. So we'll talk about how you want to set up showings on your property. Authorize the agency to divulge the existence of offers on the property, yes or no. Now, there's some issues to consider with that. So it's potentially that if you allow your agent to disclose the existence of offers, you may prevent other agents from seeing it if they find out that there's an offer. You may prevent buyers from seeing it if they've expressed that they have a desire to avoid multiple offer situations. So you want to have a discussion with your agent, the pros and cons of being able to divulge the existence of offers, and if there are certain circumstances when it's appropriate. This says that the property can be publicized in the multiple listing service, including disclosures for marketing, statistical, and appraisal purposes. This says that we can use and make exterior and interior photographs and video of said property in promoting the sale. This includes a street address on the internet. This also says that yes or no, the inclusion of automated estimated market value. The most common one that's out there is Zillow estimates. So this allows your property to be utilized upon the sale for estimates for Zillow and these other third-party virtual office websites. This section authorizes the inclusion of allowing comments or reviews about the listing on virtual office websites. So you want to talk with your agent. What are the pros and cons of something like that, where buyers can go and make comments about your home for other buyers to see? From a buyer's perspective, I can see how that'd be very helpful. What are other buyers seeing in your home that they like or perhaps have concerns about? But I have some concerns from the listing side perspective. This says that the property is or is not monitored by audio, video, or surveillance equipment. Maine is a one-party state. So as a seller, you can choose to record audio, video of people coming into your home. We want to talk about, or you'll want to talk about that with your agent, the pros and cons, and maybe some best practices regarding surveilling your home when it's being shown. This says that the agency has discussed with the seller safeguarding personal property and valuables located in the property. That's another reason why it's really important that buyers coming into your home are pre-qualified. They're less likely to have malicious intent in coming into your home, right? But either way, you want to make sure that you want to safeguard your personal property. You're putting away jewelry. You're putting away your valuables, your money, prescription medications, so that it's not readily visible. We do the best we can as agents to stay with people as we're going through the home. Every once in a while, they may go one direction or the other. We try to corral them. But the best thing for you to do is to make sure you're safeguarding that personal property. Seller acknowledges that buyers and licensees may engage in activities such as, but not limited to, photography, videography of the property. So they may come in and share that with somebody who's not able to attend the showing live. Maine law requires that buyers of property owned by non-resident sellers withhold a prepayment capital gains tax of 2.5% with the Maine Revenue Service. So if you're watching this and you have a property in Maine to sell and you don't live in the state of Maine as your primary residence, the state of Maine is going to collect 2.5% of the purchase price and withhold it as to make sure that you fill in Maine income tax. So you want to have a discussion with your agent about that as well. Next thing is a very quirky thing about the state of Maine. It says that whoever owns their property on April 1st is legally responsible to pay the taxes. So if you close on a property as a seller on December 31st and you pay taxes up until December 31st, it's the buyer's responsibility to start paying after that. But if the buyer doesn't pay, the town is not going to recognize the buyer as the new owner until April 1st. So the town would essentially send you a lien notice, even though you no longer own the property. It's something that has happened. It's something that can happen. So you want to have a conversation with your agent about this law and how they can protect you. All right. This says you're going to seek legal, tax, and other professional advice as necessary in connection with the sale. I can tell you that I've been in the business 24 years. I'm pretty resourceful, but I'm not an attorney. I'm not an accountant. So I may refer you to an attorney or accountant if you have questions I can't answer. You're going to receive a copy of this agreement at the time of signing. The agency has informed the seller of his or her obligation to provide buyers with information developed by the Department of Health and Human Services regarding what homeowners should know about arsenic in wells and in pressure-treated wood. So there are forms that we provide our sellers to provide to buyers about potential arsenic in their home. That same disclosure is needs to be made for lead paint for any home prior built to 1978. Any property management services are only provided by agency if agreed to in a separate written agreement. It says if an earnest money is forfeited by the buyer, it shall be distributed 1/2 to the seller, 1/2 to the agency. But you want to have a conversation with your agent because their agency policy may very well allow for 100% of that forfeited earnest money deposit to go to you, the seller. The seller authorizes the disclosure of this information to the Maine listings. So someone at Maine listings may require a copy of this to verify what our a written agreement is or what your agreement is with your agent. Seller agrees to hold the agency harmless for any loss or damages that may result from authorizations provided in this agreement. Fixtures. Seller understands that all fixtures are included with the sale: shutters, blinds, curtain rods, built-in appliances, heating sources and systems. I've had nightmare closings about curtain rods. So just a reminder, curtain rods are a fixture and should stay with the property. Curtains themselves are personal property, and you as a seller may take them. Personal property that you're leaving behind is in as-is condition with no warranties. However, if you're leaving behind the gas range and it's working at the time of offer and it's working at the time of the inspections and it's not working at the time of closing, you need to replace that with a reasonably similar product. Conditions, this is where you put other conditions if you're so inclined. Seller represents receipt of a transaction booklet. In most cases, you're going to check yes here. Most companies, my understanding is that they provide a transaction booklet for any residential property sale. It's filled with commonly asked questions by people who haven't bought or sold in Maine in a while or ever, with answers to those questions. Agency and seller agree that the agency shall represent the seller and that this agreement creates an agency relationship. Agency and seller each agree that this property is to be offered irregardless of race, familial status, handicap, disability, color, religion, and otherwise. This agreement may be signed on a number of similar counterparts with the same binding effect. So it could be electronic signature, it could be a fax signature, or it could be a wet signature, and it's all binding. And it goes on to say that you consent to electronic signatures. And then you have the additional information at the bottom. Here's when the agent actually signs the agreement, is when your listing agreement becomes effective. There is a cyber fraud, wire fraud advisory at the end of the listing agreement. Cyber fraud and wire fraud is on the rise. So certainly you want to do things to protect yourself, right? Millions of dollars are being lost in the state of Maine. If you look at these email addresses, they look very similar. However, one's Acme and one's Arcney. That's the kind of stuff that scammers will do to try to get your information. So you want to make sure that you're protecting that, right? Have a conversation with your agent on the best ways to do so, because there are going to be times during a transaction where someone's going to ask you for social security numbers, for wiring information. We want to make sure that we're protecting you as best we can in those circumstances so you don't become a statistic and have money lost. In the event that something does happen, this goes on to explain different things that you can do to follow through with that, as well as the contact information at the state of Maine to report any potential issues. So that's only one of the forms that agencies use when potentially selling properties. So you want to have a conversation with your agent to see if there's other ones that might fit your needs better. But thank you for your time and make it a great day. Okay, in this video, we're going to talk about the Maine property disclosure. And this particular form is for residential transactions. There's a separate one for land transactions, improved land transactions, and commercial transactions. There are certain aspects of the home's condition that are required by law to be presented to a buyer, and that a buyer has an opportunity to review this disclosure prior to writing an offer on a property. So let's go through this of what each section covers and why it's important for a buyer and why it's important for a seller to have this information. So at the top of the form, you can see that it's very property specific. That's really important to know. Okay, so we have the property located at. The first section that the seller needs to disclose information on is about the water supply. They need to disclose whether it's public, whether it's private, whether it's seasonal. If it is a private system, if it's a drilled or dug well or other. If there's been any malfunctions with the pump, with the quality or quantity of the water. They need to answer whether they've had the water tested. If so, when the most recent test was and whether that test is available. And to the seller's knowledge, if they're aware of any previous unsatisfactory test or satisfactory with notation. And if so, are those test results available? And if there was an issue, what steps, if any, were taken to remedy the problem. So if you had a public water supply, this section right here would not need to be completed. You could strike it out. So with a private water supply, we want to know the location of the well, who installed it, the date of installation. Now, for a lot of homeowners, they don't know that information. So we as agents can do the best we can to try to find that information. Sometimes that information is under the well cap if it's a private well. But in any case, these are questions that the seller needs to answer to the best of their ability. It's not enough to just put unknown in all these documents. Agents and sellers need to do some due diligence anyway to try to get answers for buyers. Number of people currently using the system. Does the system supply water for more than one household? Every once in a while, we come across a home that has a private well that's shared by multiple homes. Any comments that might go along with that, and who provided the source of information. Then it talks about the private waste water supply. So you have the water supply is the first thing that needs to be disclosed, and then information about the septic system or sewer pipes that need to be disclosed. If it is public or quasi-public, they need to disclose whether this line has been inspected. And if so, what were the results? Have they had any malfunctions? And if so, what was the steps that were taken to remedy the problem? Now, a malfunction may be something as simple as the line got blocked and they needed to snake out the line or jet out the line. But you want to find out what the root cause of that was, because it could be a sign of a serious problem, or it could be just a one-time occurrence that really is nothing to be concerned about. If it is a private sewer system, then you want to find out if it's a septic tank, it's a holding tank, a cesspool, or any other type of septic system, perhaps an overboard discharge system. We want to know the size of the tank. Is it 500 gallon, 1,000 gallon, or if it's unknown. If it's a concrete or metal or unknown type of tank, the location of the tank, the date was installed, when it was last pumped. In Maine, septic tanks really should be pumped every 3 to 5 years, depending on usage, how much usage it's getting. We want to know the name of the company so we can verify that the pumping was in fact done. Ask the question whether there's been any malfunctions with the tank, and if so, describe the problem and anything that may have been done to remedy it. The date, the last servicing of the tank, and the company that did that servicing. And then it's asking whether there's a leach field or not. There are many people that are watching this that may not be familiar with private septic systems. And a leach field is a portion of the septic system where the liquids go to be filtered in through the ground. They have specific materials in the ground that purifies the liquid as it's going through it. So we want to know if it has that type of system. And if so, where is it? When was it installed? Because the average life expectancy of a leach field is about 30 years, depending on usage and maintenance. We want to know who installed it and when it was last serviced, if it was serviced, and whether they've had any malfunctions and what may have been done to resolve them. We want to find out if they have records of the septic design. So these septic systems can be designed for a certain amount of use. It could be a 2-bedroom design that's a little bit smaller, or a 4-bedroom design, which is a lot larger. And that can impact or how long that system is actually functioning based on the size of the design compared to how it's being used. Typically, we're able to find those systems at the state of Maine registry. Is it located in shoreland zone? Yes or no? Any comments, or who's the source of information? So this section talks about the different types of systems that a home might have, the age of those systems, the type of fuel that's used, whether it's propane, whether it's oil, whether it's wood, the annual consumption of those systems, the name of the company that services the systems, when it was last serviced, any malfunctions, and any other pertinent information. The other questions on this section talks about fuel lines, whether they're buried, whether they're sleeved, whether they exist. If there are chimneys, are they lined? Is more than one heat source vented through a flue? Have they had a chimney fire? Has the chimney been inspected? When was the chimney last cleaned? Or is it a direct vent instead of a chimney system? Then there's hazardous materials. All right, underground storage tanks. Yes, no, or unknown. And if there is yes, How long have they been out of existence? Have they been abandoned according to the Department of Environmental Protection? So there's a number of questions about underground storage tanks, if in fact there was any on the property at one point. Asbestos. Any house built, in the 1960s, 50s may have asbestos flooring of some types. Asbestos was often used in ductwork for older style heating systems in the early 1900s and exterior of homes as well. So it asks about whether there's any in the ceilings, the siding, the heating system, the roofing shingles, flooring tiles, and otherwise. Has the property been tested for radon air? If so, what were the results? If the results are above the acceptable limits, what steps were taken to remedy, if any? Are those results available? Radon water. There is a potential to have radon, which is a carcinogen, in your drinking water. So you want to make sure you're testing for that. And if the seller hasn't, or they need to disclose the results of those tests. This is relatively new on the form. It's asking whether the property is currently or previously existing methamphetamine use. But bottom line is, if a seller is aware that their home has had methamphetamine in it, they need to disclose that to you. Lead paint. Any house built prior to 1978 may contain lead. The fact is, lead-based paint was stopped years before 1978, but they determined that a lot of those cans might have been sitting around in garages and used for several years after the time when they stopped using the lead paint. So they're asking if there's known lead paint, yes, no, or unknown, or it's possible due to the age of the house. And if they have any records pertaining to lead paint, they ask if there's any cracking, peeling, or flaking paint, yes or no, and where that might be. Any other hazardous materials, toxic material, landfill, radioactive material, or anything else that the seller might be aware of. And then it's talking about access to the property. Is the property subject to or have the benefit of any encroachments, easement, right-of-ways, life estates? You want to know all that information before entering into an offer, right? And restrictive covenants. There may be restrictive covenants that prevent you from do something with the home that you may want to do. Then there's the access of, is it a public road? Yes or no? If it's not a public road, who's responsible to maintain it? At whose cost, and how much does that cost? Then we get into flood hazards. In December 2024, Maine had a significant storm come through, and areas that had not typically seen flooding did. So these disclosures were recently updated. It talks about what the definition of a flood is. And then it asks the questions, has the home or has the property had any flood events? Has any flood events affected the structure of the property? Have there been any flood-related damage to the structure on the property? Any flood insurance claims on the property? Is the property wholly or partially within an area of special flood hazard mapped on the effective flood insurance rate map issued from the Federal Emergency Agency on March 4th, 2002? So if it is in fact in a flood zone, the agent or the seller will need to get that relevant panel to show what category of flood zoning it is, because it could certainly impact a buyer's ability to purchase the property if they can't afford the additional flood insurance. It asks if there's any exemptions on the property. There's different exemptions, tax exemptions that a buyer will need to know when the taxes are advertised. Does it include a homestead exemption or veterans exemption? Does it have a forest management plan? That's another important thing when you're buying a property with a large parcel of land. There could be restrictions on that land, and you need to know that. It also goes on to ask that, are there any litigation currently taking place regarding any shoreland zoning issues regarding the property? Is there any leased equipment on the property? Typical, you sometimes find propane tanks that are actually not owned by the seller, but by the propane company. The principal structure, the year built, and when the seller acquired the property, the age of the roof shingles, or whether they're metal whether they're asphalt shingles, whether there's any known moisture leakage in the roof, any additional comments. Is there a sump pump in the basement? Is there water and moisture in the basement since they've owned the property? Could be yes or no, but prior water moisture leakage. So they may have no knowledge of prior moisture leakage, but since they've owned the property, perhaps they have. In the comment section, they'll be able to describe, the level of moisture or water issues. Has the property been tested for mold? Yes, no, or unknown. If so, are they available? Electrical, are they fuses, which could create an issue for getting financing and insurance? Or is it circuit breakers or something else? Has the property been surveyed? And if so, is it available? Is it a mobile home? Is it a modular home? Are there any known defects or hazardous materials caused by insect or animal infestation inside or on the residential structure? Yes, no, or unknown, and a comment section. And then finally, there's additional defects. Any physical defects that could impact health and safety and value in the home. This is where a seller would need to put that information. Then there's an opportunity for a seller to also provide additional information that may further describe some of the issues that were found or noted in the disclosure. Seller shall be responsible and liable for failure to provide known information regarding known material defects to the buyer. Sellers, you need to be aware of that, right? It's always best to disclose, and rather than take a chance and hope that an issue doesn't present itself down the road. Neither seller nor any buyer makes any representation as to the applicability of compliance with any codes of any sort, whether state, municipal, federal, or otherwise. So a lot of times these homes were built prior to codes being enacted, or codes change after the house has been built. So sellers can't do a code review and let you know whether in fact it meets today's codes or not. As sellers, they have provided the above information and requested all the information, and they're acknowledging that it's correct to the best of their knowledge and abilities. So both buyers and sellers will sign this form. Buyers, you'll want to see this not only before writing an offer on the property. In my opinion, you want to see this before even seeing a property, so you can have a conversation with your client, with your agent, to determine, will this house be a good fit? Will it fit your needs? What are the potential costs down the road that could impact your ability to own, maintain, and stay within the home? That's the property disclosure, residential. Thank you for watching this video. Make it a great day.